Hi, this is attorney Arkady Frekhtman. I'm a New York City personal injury trial attorney. And today we are going to go over verdicts, the most recent verdicts from actual jury trials across the United States of America for traumatic brain injury. So this is going to be really interesting. I want to go over all of these cases. So what I've done is I've downloaded a PDF of all the verdicts, and I've actually summarized them in a way where we can go through more cases than we usually do. And if we want a level of detail, I could always go back to a case and do a video about that specific case. So that's going to be up to you guys, the viewers. If you want that, just drop a comment that I want to hear about case number 1 or case number 2 or whichever case you're interested in, and then we could do a more detailed dive. So let's get into it. The most recent case that I found was this case from Los Angeles County in California. And it actually was tried in the Superior Court of Los Angeles. The date of the incident was May 27th, 2023, and the trial happened on August 25th of 2025. The trial took 5 days, and the jury deliberated for almost 7 hours, 6.5 hours. So what happened in this case was it was a lawsuit against the city of Long Beach. The plaintiff was a 68-year-old man, and he was struck by a 200-pound falling tree branch while walking his dog in a city park. And so the plaintiff's argument was that the city negligently failed to maintain these trees, and the prior checks and inspections showed long-term neglect as well as underfunding. The defendants argued that the tree was inspected, it was trimmed, and it was never marked for removal, and that the city followed proper maintenance. The injury for the plaintiff was a traumatic brain injury, cervical herniated disc at C1, C2, as well as C5, C6, post-traumatic stress disorder, PTSD, as well as a concussion, and he required spinal fusion surgeries and an ongoing balance issue with his vestibular system, as well as ongoing cognitive issues. And so the result was, it was a verdict for $5,193,470.58. And it was broken down as follows. The past medicals were $82,000. The future medicals were $136,470.58. The past pain and suffering was $3,050,000. And the future pain and suffering was $1,925,000. And so after the trial, the city was considering an appeal, and they contested the future medical award, which, the future medical award was only $136,000. So, but the total was good. I mean, $5 million, it's, 68-year-old, like we said. And yeah, and I actually know the attorney for the plaintiff that handled this. I've met him a few times. We've worked on some cases together. We're actually working on a few cases now. He's a really good attorney. He teaches like an improv class for attorneys. And so, yeah, that was a great result. Okay, the second case is a case out of Florida, Palm Beach County. And the date of incident here was May 23rd of 2022. And the trial happened on August 15th of 2025. The trial took 3 days. So what happened here is that the defendant drove straight in a right turn only lane, and he broadsided the plaintiff who was turning left. And the plaintiff's argument was that he couldn't see the truck due to traffic, and there was no reason to expect a straight traveling vehicle in a turn lane. The defense admitted the negligence, but claimed comparative fault for the left turn. So they tried to blame the plaintiff as well. And so the injury was a traumatic brain injury, there was a neck injury, there was an aggravation of prior pre-existing fibromyalgia and arthritis, and the plaintiff required injections, physical therapy, as well as a rhizotomy. So the result was, it was a verdict of $405,412. And it was broken down as follows. Past medicals were $140,000, future medicals were $60,000, past pain and suffering was $100,000, and future pain and suffering was $105,000. So 405,000, it doesn't really explain, at least in this summary, what the traumatic brain injury was, but it seems like if it was just, let's say, a rhizotomy with injections, that's a really good number for 400,000. And then the third case is also out of Los Angeles, also California, and this was a date of incident of May 13th, 2019, and the trial happened August 14th of 2025. And what happened here is that the plaintiff tripped at night over a curb that was painted the same color as the asphalt outside a condo complex. So the plaintiff's argument was that the curb was unreasonably dangerous, poorly lit, and concealed. It was like a hidden condition because you got this curb, but there's no lighting, and then you got the asphalt that's the same color, and that's a tripping hazard. The defense argued there were no prior complaints. The curb has always been here. It's always been the same color. The lighting's been the same. Nobody's ever fallen. Nobody's ever even mentioned this as an issue, right? No complaints. And that the plaintiff is responsible for not watching where she was going. So kind of like an individual responsibility, right? Like you're responsible for your own actions. You're walking. Be careful, So what happened here, the injury was a concussion, a facial laceration, and there was a claimed ongoing cognitive and speech issue. And so the result was interesting. There was an apportionment of fault, right? So basically the plaintiff was found 65% at fault, and the defendant, one company, was found 30% at fault, and then the homeowners association was found 5% at fault. The total amount that the jury awarded in the case was $3,335,000, but because the plaintiff had 65% fault, the actual amount, the actual net amount that the plaintiff got was $1,167,000. So a very interesting case, and that's what happens a lot of the times in trip and fall or slip and fall cases. Now the next case is a case out of Miami, Dade County. So right now it's like Florida, California, California, Florida, for whatever reason. But this is a case where the incident happened September 14th of 2018, and the trial date was August 5th of 2025. And here it was a rear end crash, liability was admitted. The plaintiff's argument was that he was claiming $200,000 in past medicals as well as future surgeries. And the defense argued the plaintiff refused injections that could have avoided the surgery. There was like an opportunity where the doctor said, hey, I'm going to give you an injection, and this injection may help and you won't need any surgery, but the plaintiff refused. The defense also argued that all these bills, these medical bills, were inflated and that the injuries were very minor. Now, the injury summary says that there was a traumatic brain injury, there was a cervical and thoracic herniation, there was a fusion at C3, C4, and there was also a claim of cognitive deficit. And so, like I said, this is the 11th Circuit Court in Miami-Dade County, and the result was a defense verdict, 0. Here, the jury found the negligence was not a cause of the injury. So there was negligence. They admitted the negligence, right? Because it was a rear end, but they said, hey, this is not what caused this injury. Something else might have caused it, or it might be from living your life, but not from this crash. The next case is actually out of Philadelphia, and it's in the Court of Common Pleas. The incident happened April 15th of 2017, and it was a settlement, and the settlement happened August 4th of 2025. So what happened here was that the plaintiffs got hit by an illegal dirt bike, which was being chased by a Philadelphia police officer in violation of policy. So the plaintiff argued that the pursuit was reckless and violated city pursuit restrictions, because I guess they have certain, city rules. They have the officer's training manual, they have the police academy training, all these things, right? And so the plaintiff said that's reckless, right? And that violated your own city pursuit restrictions. But the defense said the pursuit was justified and the accident was unforeseeable. We couldn't have imagined this could happen, that, you would get hit by a dirt bike that's being chased by a police officer. And so the injury was, there was a 6-year-old, and he had a severe traumatic brain injury with a subdural hematoma, craniotomy, which is a surgery of the brain, and pelvic fractures. And there was another person with a concussion and nasal and rib fractures. So the result here was that the case settled, and the settlement was 2.9 million. So it was 2.5 for the child with the severe TBI, and it was 400,000 for the aunt. The aunt was the other individual that was an adult that was injured. Okay, and now the next case is actually out of Texas, Denton County, Texas. And what happened here was the incident was in 2023. The trial was July 23rd of 2025. The facts were that it was a sideswipe crash. The plaintiff was seeking $1 million in UIM coverage, which is uninsured motorist, right? Coverage. The plaintiff claimed $3.5 million total damages for lifelong injuries, and the defendant argued that these are degenerative conditions and psychological causes unrelated to this crash. And so the injury was a TBI, cervical and lumbar herniations, depression, and radiculopathy. And the jury awarded 0 damages. No, it was a defense verdict. And yeah, so that was unfortunately nothing. And then the next case, here's a case out of Connecticut. This was in New Haven, Connecticut. It was in the Superior Court. The date of incident was November 18th of 2021, and the trial date was July 18th of 2025. Here what happened was a tractor trailer rear-ended a stopped vehicle, and the driver claimed it was a sudden emergency. So the plaintiff argued the truck failed to stop, and there was a mechanical issue that caused the stop. And the defendant argued there was no negligence by the trucker. It was just a sudden stop that was unavoidable. And the injury was a traumatic brain injury. There were cervical herniations, and there was post-concussion syndrome. And so what happened here was that there was a mixed verdict. The verdict was for $41,522.83, but it was only against a co-defendant who was in default. And I guess there was no verdict against the defendant that was actually in the trial, that was actually part of the case. Here's another. The next case was a case out of Texas. The incident was in 2024, and the trial was July 15th of 2025. The facts were pretty simple. It was a stop sign crash. The defendant did not testify, and the defense challenged the credibility and the severity of the injury. And the injury was a TBI, multiple spinal and shoulder herniations, as well as tinnitus, which is ringing in the ears. And so the result was, for one of the plaintiffs, she got past medicals of $20,000, future physical pain of $5,000, and future impairment for $5,000, for a total of $30,000. So kind of a low verdict, but you kind of see that often in Texas. It's more conservative. This is in Denton County. Now the ninth case, we were up to 9 cases already. Here's a case out of Los Angeles, and the incident date here is May 12th of 2017, and the trial date is July 14th of 2025. And this is a tractor trailer rear-ending a van. So the tractor trailer rear-ends a van after the driver becomes distracted because he drops a water bottle. So the plaintiff argued this is a distracted driver, this is a speeding driver, and this is what caused the crash. The defendant argues he claimed the father drove too slow. So I guess he's claiming the plaintiff drove too slow, and that contributed to the collision. And so the injury was a severe TBI for both sisters. There were like 2 sisters who were injured. There are 2 plaintiffs. There was incontinence, and there were cognitive decline and memory issues. And so the result was they found 82% of fault on the truck driver, and the verdict was actually $21,253,467, but the net amount will be slightly less. It'll be $17.4 million net to the plaintiffs. Okay, and the 10th case that we could do today is a case out of New Jersey. This is Middlesex County, New Jersey. The date of incident was May 17th of 2019, and the settlement date was July 1st of 2025. The facts here is that an armored truck merged improperly after the toll plaza, striking the plaintiff's minivan. So the plaintiff's argument was this is clear liability and they have lifelong cognitive and sensory impairments. And the defendant's argument was that they wanted to settle pre-trial after the mediation and focus groups. They did focus groups for this case. The injury was a severe TBI with a skull fracture, an epidural hematoma, cognitive deficits, and hearing and vision loss. And so it was settled, and the settlement was $6 million. So a pretty good settlement. And I don't know if I said this was a May 17th, 2019 incident, and the settlement happened July 1st. And that's 10 cases we've done. Let's see, just look through some of these others to see if there's any others that may be worth discussing. Here's an interesting one out of Queens. What happened here was an Uber driver was rear-ended by a company van. The liability was conceded. So the van said, yeah, I'm at fault. I'm sorry, I hit this Uber driver in the rear. The defense argued that it was degenerative conditions and there was no traumatic brain injury. That's the defense argument. And the plaintiff proved a causal link between the crash and the brain injury, as well as permanency, that this was going to be forever. The date of incident was December 4th of 2019, and the trial happened June 5th of 2025. And like I said, this is Queens County, New York, in the Supreme Court. And the result was, okay, a total of $3,900,265. The past pain and suffering was $320,000. The future pain and suffering was $1,792,000. The future medical was $805,048. The past lost earnings were $137,500, and the future lost earnings were $845,717, for a total of $3.9 million. So a pretty good result there. Oh, and I didn't go over the injury. The injury was, there was a traumatic brain injury, there was cervical and lumbar fusion, so 2 fusions, there was a rotator cuff tear, there was chronic pain, and there was neurocognitive therapy. And that's just a short summary of it. There's more information. We could maybe do a deeper dive into this case. It's kind of an interesting one, actually. Let me see if I could pull it up in a different screen, maybe to see who the lawyers were, so I could get some more information about that case. Let me see if I could get back into here. That was the 10th case, right? Just gonna pull it up over here. Oh, here it is, yeah. Let me just pull it up here, see if there's any more information in the full write-up. Oh yeah, okay, so I recognize the doctor, the surgeon. I actually used this doctor in one of my cases as well, the surgeon. I recognize the neuropsychologist. I've actually used that doctor as well in one of my recent cases. I recognize actually everyone in this case, all the experts. And oh yeah, I see who the plaintiff's attorney, I know the plaintiff's attorney's firm and trial attorney as well, they're pretty good. And oh, they use the same economist that I use. Oh, so they use a lot of the same experts, yeah. And I recognize the defense firm. So that was a good, yeah, pretty good result. I mean, in terms of the injury, well, he had 2 fusions, so that's pretty serious. And they just talk about some of the treatment, like pain management, things like that. And then some of what they had for the brain injury, like the diffusion tensor imaging and abnormalities, cognitive testing, things like that. So it goes into a little more detail. But yeah, 3.9 million. The demand was 10 million. The offer was 2.2 million. The trial took 8 days and the jury deliberated for 6 hours. And the jury vote was 5 out of 6, because we have 6 jurors in New York. So they had 5 out of 6 agreed on questions of significant limitation of use, which is one of the categories to show a serious injury in a car crash. So you get over the no fault threshold. And it was 6 out of 6 on all the other questions. So everyone else agreed on all the other questions. And the jury composition was 2 men and 4 women on the jury. So that was a good, interesting case. And let me pull up the rest of my summary to see if there's anything else that we should discuss. I think that's pretty good. So I mean, we kind of see, verdicts are rising. Average TBI verdicts are rising, particularly in California and New York. Juries, usually allow for money damages when there's proof, like documentation, evidence of proof, and also when the plaintiff is credible, right? They have to believe you. Once they think the plaintiff is like faking or a liar, you're gonna lose. And it seems like also the government and corporate defendants are the ones like there was the tree maintenance where it was the government, right? It was the city of Long Beach. There was police pursuit where it's the Philadelphia city. There was corporate trucking where those were some of the bigger verdicts. And the defendants' themes that you see are that these are pre-existing or alternative causes, it's a low-speed impact, or that it's degenerative, not traumatic. And then the plaintiff's success, they kind of humanize the loss, right? They say, hey, this was a teacher, they had to give up teaching, they lost lifelong love of sports, or whatever the loss was, right? And also they showed clear negligence, they showed indifference on behalf of the defendants, and also a strong expert lineup using like orthopedic, life care planners, neuropsychologists, whatever is needed to prove the case. So yeah, I hope this was helpful. Let us know what questions you have. Let us know what videos you want to see. If you want any of these cases to be done as an individual video or more of a deeper dive, we can do that as well. Our goal is to help serious injury victims and families. Please like and subscribe to our channel. And remember, we are here for you. If you need a consultation, just text me. It's 347-566-9595. All the best, everyone. Bye-bye.